So, in our last lecture, we talked about the concept of relational distance and how that affects the handling of legal cases, and the concept of cultural distance is pretty similar. Cultural distance refers to differences in culture being the symbolic, expressive aspects of human life, things like our ethnic identities, our religious beliefs, our dresses and fashions, our languages, and other sorts of symbols we use to distinguish one another and to express our feelings and thoughts. So cultural distance refers to differences in these things. So people who have the same language, the same religion, down to the same subculture are very culturally close to one another. And people who have different dialects of the same language, or maybe different sects of the same larger religion, like, Baptist and Methodist might both be sects of Christianity, or different subcultures, like they're both part of, modern American culture, but one's more of a hippie, one's more of a goth, one's more of a punk, one's more urban, one's more rural, that kind of thing. That's a bit more cultural distance. And still more cultural distance is when they're speaking different languages altogether, not just different dialects, but completely different languages. When they have completely different religions, like Christianity versus Hinduism or Islam or something like that. And they belong not just to different subcultures within the same larger country, but to different civilizations altogether. Different cultures that have separate histories going back thousands of years. And so just like legal cases might cross more or less relational distance, they might cross more or less cultural distance. A legal case is culturally close when the people share all these cultural characteristics, and it's more distant when they don't share cultural characteristics. And so the theory here works pretty much the same way as the theory in the last section we looked at. Law varies directly with cultural distance, meaning the more culturally distant the parties in a legal case are, the more law the case is likely to produce, meaning the greater likelihood of legal involvement, the greater the extent of the legal involvement, the greater the likelihood of a punishment for the alleged deviant, and the greater the likelihood of a severe sentence and all that kind of thing. So cases between victims and offenders who are culturally close tend to result in less law than cases where the victim and offender are culturally distant. And I want to stop here to bring up one point we haven't yet addressed. When we talked about the social structure of cases in our last section, we considered law as a settlement. Party A has some sort of complaint against Party B, and then they turn to the law to handle that complaint. And we look at how the relationship between Party A and Party B affects the likelihood that they'll turn to the law. And we've established that it's more likely when they're distant than when they're close, whether relationally distant or culturally distant. It's more likely when the offended party, the one with the complaint, is a social superior than if they're a social inferior. And so that makes law more likely. But what about cases that don't match this scenario? Cases where there's no victim and offender. Cases where the law acts on its own without a citizen complaint. For example, you might be driving down the highway and you get pulled over by a police officer for speeding, and none of the other cars around you picked up their cell phones and called the police to complain you were speeding. In fact, maybe they were all trying to speed too. Maybe there's no one who would even define what you did as wrong, but the law defines it as wrong anyway. Likewise, we have so-called victimless crimes, and you might differ in your opinion about whether they should be crimes or not, but say you're smoking marijuana on the front step of your porch. Maybe everyone in your neighborhood is cool with it, but a police officer drives by and sees you smoking marijuana and is not cool with it, and they define what you're doing as criminal and take you to court for it or take you to jail for it. So you have these cases where there's law, but there's no party you can identify as the complainant or the victim. And so how do we understand these in terms of social structure of the case? And the way we do this is we just view this as a two-sided case where the law or the legal officials are one side. And so in this case, the direction of law is from the legal official towards the defendant, towards the accused. And we would say, okay, the social structure of the case now is defined by the amount of social distance and inequality between the legal officials and the alleged deviant. And if we look at it this way, all the same relationships we've already talked about still apply. Law still is greater in a downward direction, and it still increases with vertical distance in a downward direction. Legal officials generally are superior to citizens. They have the power of the state backing them. That gives them a great degree of superiority. But their amount of superiority will vary with the status of the alleged offender. So, a high-status offender is less inferior to legal officials than a low-status offender is. Or to put it a different way, legal officials are more superior to somebody who's socially down and out than they are towards someone who's very high status. And so you'd expect, all else equal, cases where the law acts on its own against an alleged offender, like pulling someone over, giving them a speeding ticket, or punishing them for using drugs or something like that, you'd expect the law to be more likely and more harsh towards people at the bottom of society than towards people at the top, because there's a greater degree of inequality between the legal officials and the people at the bottom of society than it is between the legal officials and the people at the top. In fact, maybe in some extreme cases, you could actually get people who are so high status that they're above the legal officials and so kind of above the law. So even when the law is acting on its own, it's like upward law. And you don't see this as much with individuals, but maybe with very powerful corporations, or maybe like in earlier times in history, the aristocrats, the nobles, they would be superior to legal officials and get away with murder, basically. Likewise, we could look at the social structure of the case, its horizontal structure between legal officials and the defendant or alleged deviant, and the greater the relational and cultural distance between the alleged criminal and the legal officials, the greater the quantity of law. So you would expect legal officials to be more likely to make arrests and bring harsh charges against people who are strangers to them than against people who are intimate with them. It's pretty common if you are a law officer, if you are a police officer, if another police officer pulls you over, you say, hey, it's me. I work for the same department. Can you let me go? And then they, get a ticket. Or if your family is tied to the police, like your uncle or your dad is a cop, you can do the same thing. In a lot of places, people kind of have an understanding that they're lenient on those who are personally tied to law enforcement. And you might expect the same thing on up the ranks. You might expect prosecutors to pull punches if it's somebody who's a friend of a friend, or judges to be a little biased in favor of somebody they know, or jurors to be biased towards somebody from their hometown and against somebody who's a stranger in their community, and this sort of thing. And so law increases with relational distance between the legal officials themselves and the defendant. Same thing goes for cultural distance. As the cultural distance between legal officials and the defendant increases, you'd expect law to become more severe. You'd expect higher probability of arrest, more severe charges, more chance of conviction, and so forth. And one place you could see this sort of relationship is in how legal officials respond to those with extremely low status characteristics, or those who are members of, very distant cultural groups. And you can see it in things like, police use of force. Which brings up another point, which is that, remember, we're defining law as government social control. So anytime a government official metes out social control to citizens, it counts as law. This is a behavioral definition of law. It follows legal realism in defining law as what law does and not as rules on the books, which means you could have something that, sociologically speaking, is law, but is also, according to the written rules, illegal. There's such a thing as illegal law. And so if, say, police officers respond by beating the heck out of a suspect, that's law, even if the law on the books would say this is excessive force and illegal. And even if they, in turn, might later be punished for committing a crime of using excessive force, it still counts as law. And so the theory of law helps explain things like why you get, say, police beating suspects or acts that observers might define as police brutality. You would tend to get these towards people who are very culturally and relationally distant from law enforcement, strangers and members of minorities and members of different cultural groups, and towards people who have lots of different low-status characteristics. For example, homeless vagrants, people who lack wealth and education and integration into society and whose lifestyle might be viewed as extremely deviant, like they might be alcoholics and drug addicts and other sorts of characteristics that are seen as deviant. They tend to attract quite a bit of physical violence from law enforcement. Not from every officer, obviously, but if you were to point to one demographic in society that's likely to be beaten just for standing in the wrong place, it's probably going to be people who have all these low-status characteristics. This doesn't really happen to people at the top of society so much. One final point to make is the relationship between law and other social control. And we've addressed this briefly already, so I'm not going to talk too much about it. But there's this idea that law varies inversely with other social control. One thing we can do is try to think of this in conjunction with the other relationships we've talked about, like the effects of relational distance and cultural distance and inequality and vertical direction on law. If those relationships hold, if they're true and they predict when people are likely to turn to the courts, that also means they predict when people are likely to turn to alternatives to the courts. And those alternatives can be good, bad, or ugly. In some cases, we might think the alternatives are superior to law. We might think it's better if people, sit down and talk things out rather than file lawsuits against each other and clog up the courts. On the other hand, some of those alternatives we might think are worse than law. People might be turning to things like violent vengeance, for example. It's also worth pointing out that this relationship between law and other social control can swing both ways. It's partly a matter of people turn to law when and where other means of social control are lacking. So you get a bunch of people who have no established mechanisms of resolving disputes or handling deviance, and they're more dependent on the law than they would be otherwise. But you can also get something that happens where law supplants other means of social control. You get a situation where the law comes in and takes over conflicts, and maybe that sort of makes other ways of handling things wither out and die. We'll return to that idea a little bit towards the end of the course when we talk about potential legal reforms. Some reforms will hinge on getting people to rely more on other forms of social control than on law, and that might actually mean, for selected types of case, trying to make law less available. But again, that could be a double-edged sword. Maybe the alternatives that crop up in the absence of law are things we would not prefer. Speaking of the final section of the course, where we talk about legal reforms, so far we haven't delved very deeply into Black's book, Sociological Justice. I've just assigned the first chapter, which summarizes a lot of the stuff from this section. It's a really good summary. And we'll save you reviewing every lecture I've recorded. But when we get to the final section, talking about reforms, that's the majority of what that book is. And so if you haven't gotten it yet, try to get it before the last section of the course. It'll make life a lot easier.